Juries, how are they selected? Well, that takes us to this week's legal video blog. Well, in order to serve on a jury, first somebody must receive a subpoena. They show up and they are placed in a pool of individuals, a large group of people, from whom juries are selected. The selection process takes place when a group of people, part of that large jury pool, go to a courtroom. The courtroom will be trying a case. There are two kinds of cases that are tried. There are criminal cases, there are civil cases. Civil cases at the end of the day are basically about money. Criminal cases are about whether a bad guy did something wrong and needs to go to jail, or in the extreme case, face the death penalty. So when a jury considers a criminal case, it's different than considering a civil case. In a criminal case, it's pretty straightforward. People will always talk about elements of a crime. Let's take an example, robbery. In order for a robbery to occur, someone, a bad guy, must approach somebody and take something of value as a result of force or a threat of force. Threat of force can be pulling out a gun, as an example. So you have two things. Something's taken, and it's taken by force or with the threat of force. When a jury is considering the evidence, those are the two things they have to consider in a robbery case. And if they find them both present, they find the guy guilty. Civil cases, much different. In a civil case, you many times have a whole lot of other stuff to consider. A lot of civil cases that are tried are injury cases. In an injury case, you have to determine what's the reasonable standard of care that must be maintained by the person who's accused of wrongdoing. Generally, we all have to act reasonably and prudently. You don't drive your car into the rear of somebody else's automobile. But when you start to deal with professionals, accountants, architects, doctors, standard of care is sometimes very specific, and it requires expert testimony, and many times you'll get different experts who will testify somewhat differently. Then you have to make a determination, if you found that there was a violation of the standard of care, as to what kind of damages. How was the person who brought the suit hurt? And that's all going to be about money, medical expenses, loss of income, and a variety of other things. So, two different kinds of cases that are tried. Much more difficult in a civil case than in a criminal case. The attorneys who are on both sides of the case, the person who brought the case, the person who's defending the case, whether the individual is a prosecutor and a criminal defendant, or whether that's a plaintiff who has brought the case and a defendant, they, the attorneys, both get to ask questions. It's voir dire. That's what it's called, voir dire. They have an opportunity to ask questions. What are they trying to do? They're trying to find people who are without bias, without prejudice. Some people, in civil cases, feel nobody should ever get any money. Nobody should ever get any money. Some people feel, oh, too much money is being given away. They've never actually been on a jury before, but they hear some news stories and they think, oh, too much money is given away. And they come with a predetermined approach. They are prejudiced. You don't want those kind of people serving on a jury. And when you have to try and figure that out, well, you do that by asking questions. The attorneys do that by asking questions of the juries. But there's some attention that occurs here, because there are rules that apply. The attorneys can't ask every single question under the sun, and there are rights of privacy which exist, and so therefore not every question that the attorneys would like to ask can be asked. And we also recognize, as you're probably well aware, a lot of people don't like to serve on juries, so everybody doesn't necessarily show up when they get a subpoena. And you've got a judge who wants to have that case go forward and a decision made. The judge wants to see, in some instances, that as many people can stay on that jury panel as possible, because there may not be enough people to replace them. Therefore, you sometimes have a situation where the two attorneys are trying to get rid of people who are in any way going to be biased or prejudiced, and you've got a judge who says, hey, we can't get rid of too many people, because if we get rid of too many people, we won't have enough people to sit in the jury box. So you have that tension which exists. And that sometimes makes for some fireworks that occurs during the voir dire process. You also have situations where people aren't going to always be entirely honest, and efforts are made to try and get people to be as honest as they can when they're asking questions about why they will or will not serve on a jury. At the end of the day, when somebody finally passes through all of this screening, they get to serve on a jury. And that's a very important thing that they get to do, because we enshrine in our Constitution the right to a jury trial, particularly in criminal cases, because we, the people, want to have a right as part of a community to help make decisions that form what our communities are like, the kind of people who should be in jail, the kind of decisions in which money should be awarded to people. So serving on a jury is not only a privilege, but it's also a way in which to make sure our Constitution and our laws are enforced. I'm David Allen. We bring you this case, we bring cases every week so you understand how the law works